pulled up.
Oh, I should have wrote writs on it. I didn't write writs. All right, it's preparing. It's going to start in like 3 seconds. You guys will be live.
Okay.
But you're live and
okay.
So you can start whenever you want.
That's declaration at 12.
All right. So
Let me
this is done. Redirecting to YouTube. Okay, here it goes. All
Okay,
right, so this is live on YouTube, and it's Nicholas Herring teaching on writs.
Okay, give me a second to get these up, folks. In order to share them, I have to have them up. And what's nice is they're actually pretty easy to once I give you the directions, it's going to be pretty easy to edit all of them. Whoops, I've got the wrong ones coming up. Hold on. Give me a second here. Need the state writs.
Okay, which one says the state writs? You got the bill legislature, the quorum nobis, final
yeah. Yeah, so what we're going to be going over is the 1/17/2019 bill for bill legislature final, the writ of error quorum nobis final, and the writ of error quorum nobis legislature final. And before we even get started, I'm just going to say that these have all just been filed in Arizona by one of our own in the Supreme Court and the legislature down there. So as far as he did have to pay a fee to get into the Supreme Court, but the legislature, when he took him in there, and he filed both the writ and the bill, they actually had to bring an attorney out because they said they couldn't file them without the express permission of an attorney. The attorney took a look at them and accepted them. They've been filed in Arizona, so they have.
That's great. That's great.
Great. How much? I wonder if it's across the same board. You file them in your state courthouse, or?
Well, you can file them in both your state case within your court. It's probably best to hit all levels. So you also want to file it with your state Supreme Court, and then also the bill and the writ gets filed with your legislature. And so you're hitting them on all three fronts there so that they're all aware. And then I'll get into showing how to edit these. And we've kind of changed it from the ones that were filed today. We've changed what we're actually going to pull out as far as the proofs of claim and leave in. So it's going to be important to I believe we've already talked about that with Ghost. I think it was several nights ago, but I'll just go over that in clarity today.
Okay, so I'm wondering how much it cost them for the Supreme Court?
For the Supreme Court, it was a $250 filing. Now, what you could do is prior to filing, actually hand them the judicial notice and other, which in accordance with I believe it's Article 3, Section 2, the courts are supposed to be open. So there should not be any fees. And you can argue that, but as of today, with the fellow that was filing them, because he didn't have that on hand, he just paid up front. He'd rather just get them in than argue with them at this point.
Right.
What was the payment when you pay it?
$250. It was $250. So. Well, 250 Federal Reserve notes that are absolutely worthless in the first place. So big deal, That's the way I look at it.
Right. Okay.
Now, with the legislator, do you do the House and the Senate both with both documents, or does one go to one and one go to the other?
No, both the writ and the petition or the bill of grievance go to both the Senate and the House. So you have to hit both clerks.
Okay.
Now, it's going to be questionable as to whether or not the House will allow it, but the Senate will, period. I believe
Right.
that he.
Where with the legislator,
Senate.
don't they want sponsors, or they want you to have a way in?
Well, technically, yeah. But here's the thing: is if you don't know anyone, it's better to go to the clerk and get it filed, and have them contact you.
So by questioning curiosity, can you have like basically they did it the person that filed it already, they did it personally, or did they have other people on there?
They did it all by themselves. It was a singular petition.
Singular petition.
And it's similar to the remonstrance, but it is a petition of grievance. And we'll see that shortly here.
Okay.
Okay, let's see here. I'm going to start with the bill for the legislature because it is the main one that you're going to want to utilize. Can everybody see that all right? And am I clear? I'm not breaking up any?
Yeah, you're good.
Okay,
Yeah,
because
you're
we've been
good.
having problems with me breaking up. So the first thing that's going to need to happen is this right at the top here where it says the qui tam pro domino. That's only going to need to be removed because what qui tam is it's a class action whistleblower suit, and it's also on behalf of the king. And so you since you're going singular, you're not doing it on behalf of anybody. You're doing it on behalf of yourself, so that needs to be removed. As you're going through, you're going to see, like right here, it's in the filed into the legislature of West Virginia is our template. You're going to want to make sure that that's your state.
Okay, what part am I getting rid of? It's okay, I've got it open. It's the qui tam pro domino.
It's the qui tam pro domino reggae Guam pro se
Okay.
ipso in hoc parte sequitur pro rex regum et heredes. That is on behalf of the king.
Okay, so leave that in there or
No, that's going to be removed.
okay. I just want to make sure. Okay.
I am the king.
I am a queen.
We are the kings. We are the queens. We have to understand that. But when we're doing this is a statement for doing it on behalf of the people.
Yes.
And since we're doing it on behalf of ourselves, we're not going to utilize that.
All right.
Now, yes, you can do this with multiple people in a group. You just have to make sure that you edit it for that. This is just the bill of petition and grievance. This is actually going to be after the writ. But since what's in the writ is in this document, I'm just going to go over this document.
Okay.
Then I'll briefly go over editing the headings in the other documents. So this is filed on behalf, filed into the legislature of your state. So right here is wherever it says your state, that's going to need to be altered for your state. This whole excerpt in the beginning talks about exactly what's supposed to happen within the legislature in regards to a petition of grievance. I just encourage you to read it, understand it. And this is an equitable, extraordinary, and other remedy is required and necessary. Now, the states, a lot of people are finding the states have decided to essentially abolish writs. That's a violation of Article 3, Section 2, so ignore them.
So leave it in there?
I would leave it. I would leave in there what the writ is in the first place.
Okay.
And we'll get to that when we actually get to the writs themselves.
Okay.
Here is where you're going to put in your name. You're going to remove all of these names. Put in your name and the alleged matters. Now, remember, they're alleged matters. They are not cases, because what we're claiming in these is that they never had lawful authority in the first place. So they are alleged matters. They are not matters. So this is where your case number would go. and your name. Of course, wherever you see your state, you're going to change it to your state. Wherever you see West Virginia, you're going to change it to your state. Keep it in the exact same context, being uppercase or lowercase for your state.
Oh, look, I magnified it. Heck yeah, looky there. All right. All right.
Let me increase this in size really quick first. Hold on. Everybody can see it. Whoa, yeah, I didn't want to do that. Hold on.
Yeah, I'm going to go through and I'm just going to mute people's background noise. You guys can unmute if you have to talk.
Hold on. I don't know what just happened there, but I did something and I don't like it. So
Okay, no problem.
let me back out of this and come back in. Did not do what I wanted it to do. Give me a second here. I apologize for that.
Nick, you can hold down shift and use your scroll bar in and out, and it should go and zoom in and out.
Okay. Well, it's I was using control and then trying to zoom in.
Oh, that's
Now
it. You're right. Yep. That's actually what I meant. Sorry about that.
Problem is here now it's put me into a different it's put it into where it's in plates where I'm seeing each page.
Yeah,
in plates.
you're zoomed out a little bit too far.
Okay, hold on. So I'm trying to, oh, there we go. There we go. Let me just, oh, come on. Okay, let me try that again here. Sorry for the hiccup there, folks. Where are you here? Okay. So, okay, where I was, let's see, right here, wherever it says state of, you need to make sure that your state's in there. Make sure that if it's an uppercase, you leave it in uppercase. One of the most important things, and this is going to take some research. Let me get to it here. The Constitution for your state would have occurred in a certain time in the congressional record. So you're going to have to look up your congressional record in the statutes at large to find out when. You can see right here, West Virginia occurred in 1872. Well, it really was one of the first of the, it was one of the 13 original states. You're going to need to go and find on the statutes at large the act of your state being added to the union by the legislature, and then also the act by the president and of him signing it, or I should say him or her, but it really is hims at this point, signing it into law. What you're looking for is the wording to your state being admitted, and what it's going to stay, and I can guarantee this on every time that you find it in the statutes at large, on the in regards to the congressional record, your state was brought into the State of the Union on equal standing with the original 13, but it does not state that it was Republican nature, which is what we're getting at in this paragraph here. And so you're going to have to go there and find exactly when your state was established and change the date to the year that yours was entered in unlawfully to the Union under a constitution that was not republican in nature. That's important. And so you're going to update all of these dates as to when it was entered in incorrectly. And after I'm finished going over the editing, I'll show you how to do that. It's quite a long process of searching through, and I'll just use a state that I've already used as an example. Otherwise, in this, this particular statement, In the writ, you're going to have to make sure that, well, first of all, the dates are right. Make sure that you edit for your state, so it's talking about your state. And anywhere that it mentions the United States, leave it as is. When you get to the following documents and tangible mediums and specificity, if you haven't filed anything into your original state case, you're not going to put anything here, so this could actually be removed. Like with mine, in my state, I filed a constitutional challenge to state statute, so that's something that I would put under this heading. And also, I moved to dismiss all child-related issues in my cases for constitutionality. This is where you'd add that in. But otherwise, all of these are someone else's documents that they've entered all the way down to this point down here. You're going to remove all of those, all the way up to the proof of claims. Okay? So it's this whole section. If you don't have anything to put in there, just remove it.
And that's where you put in the constitutionality?
That's so like since I challenged jurisdiction and challenged the constitutionality of the state statutes, I would put those documents in as when they were filed, where they were filed, and that would be the grounds for part of the grounds for this writ.
Okay. I haven't filed anything, so.
Well, that's all right. The writ it still has enough power where it doesn't matter, or at least it should. But we're dealing with criminals, like we've talked about before. So,
yeah, these jackasses are trying to tell me I got to do something different.
Well, then do something different. File the writs.
I am, exactly. Yeah, they're trying to say I need a guardian ad litem due to the fact of the paperwork that I'm going to present.
Oh, so are they're challenging your
competence.
Your competence.
Yeah, but I've had 4 assessments. I said that's not. I am competent. This is not. I don't want to get off sidetrack. I'm sorry. I will talk about it later.
Fine, that's okay. Ask questions away. You know, it's because that's part of the reality of all this. So
yeah, that's
hello.
This new you know, that's what we were supposed to have court today. So I'm on the way up there, and then the baby's mama called and said it had been continued, and I said continue. So I'm supposed to be there at 2. This is about a quarter till. So I'm in a frenzy to get up there, and so it had been continued till 2 weeks from Tuesday. So I said okay. And so anyway, that we talked for a minute. He said, well, because his bill of discovery, they motioned for bill of discovery. They were supposedly had a CD. As I went into the other week, we had these words for the judge. Some allegations got fed, and then this public pretender jumped up and he objected. And then the judge kind of swatted him down and allowed the social worker to continue. And I told him standing there, I said, your services are no longer needed. Under what law? And I filed a motion, and I filed the declaratory judgment. And here's your copy, and there's your copy, and I don't understand why we're going forward here. She's making more allegations, and so forth. So anyway, that went on, and that's what I got into last time.
Okay.
And so this time we had court today, and I'd already let him go, and I told him his service is no longer needed, and so now he's saying he texted today. I was on the way up there. I'm going sui juris, and he said that he's going to make a motion that I need a guardian ad litem. And I said, on what grounds? He said, well, I don't understand this paperwork that you're impairing me, that you compel me and want me to file. I said, that's why I said your services are no longer needed. I've emailed you the letter request telling you that I have relieved you in honor. So this is what, So
okay.
Anyway. Yeah.
Well, it sounds like you've done everything you need to do for that. So, you know, if they want to challenge your competency, hit them with a writ. that's your competency right there.
I'm going to anyway. But I've already had 3 assessments.
So,
That's what I told this guy to begin with. I'm not a ward of the court. I'm not incompetent, and I can handle my own affairs. But I challenged her judge the other day, and I told her, I just said, I don't need you to tell me what I can do and what I can't do. I've jumped through hoops for 820 days, and this is where we're at today. So
yeah.
Okay.
Well, now it's time to get them with some of the facts, and that's where proof of claims come in, and we're about to go into the proof of claims.
Thank you.
Has everybody looked at the writs and read the proof of claims, or at least tried to? Because there's a lot of them.
Yes, I have.
You have? Okay.
I have. Yeah,
okay. So in these writs, what we're as we're going in personally with the writs, we're going to use the proof of claims 1 through 114, and then 505 through to the end. Let me double check this to make sure I've got that right. Yeah, 505 to the end. So 1 through 114, if you've read them, I just, I myself went over them again today, even though I've already read all these once. 1 through 114 go through all of the powers and the requirement for what's the word, a clause or a granting clause that grants them the ability to make the laws in the first place. That's what 1 through 114 does. Okay. It also goes into the 1933 or 1913 creation of the Federal Reserve, and the 1933 removal of gold and silver from the people, forcing the common law of this nation out, and only giving us the ability to get equity if we want to find any relief or remedy at all, which is in direct violation to our Constitution. So I encourage you to read 100 through 114. 115 through 505 you can remove, because they deal with criminal. Now, unless you've been arrested or have had other issues in regards to arrest, 100 through or 115 through 505 is probably not going to be necessary for what we're trying to do here, because it talks about false imprisonment, as we can see right here.
What if our child's been in custody? Would those be left in?
Well, you can examine them and decide if you want to leave them in or not. It's okay. You may have to change the structure of the proof of claim, but that would be something you would want to run by somebody else who really understands this really well.
What do you mean the structure?
Well, so if let's say if a proof of claim was talking about false imprisonment, or you would want to change it to a false custody.
Okay.
Or false requirement custody to or appointment of of something outside of their lawful authority to do, such as a guardian ad litem. But I wouldn't recommend that. I would just pull those.
Okay.
Okay.
Unless you really know what you're doing with these proofs of claim that can get you in a lot of trouble if you don't word them correctly.
Yeah, I don't.
In reference to that, if they're being, like I said, and detained, warehoused, or without unlawful, just don't put anything in, right?
Right. I mean, I believe in 1 through 114, it actually specifically talks about children and custody, so you shouldn't have to anyways.
All right.
God, it would. Let's see here if I can find it. And I just read it not too long ago. So again, yeah, if you can't write these on your own, I wouldn't. I would just stick with what's here. It really does get to the real heart of the issue, anyways. Yeah, I'm probably not going to be able to find this offhand because I don't
That's
remember
okay.
the number.
Okay. I understand that.
Okay.
It's just a matter of make sure you sit there and proofread, double read, whatever you have to do to understand the 100 through 114.
Yeah, I got you. I seen it. It just I was on mute and I couldn't say nothing. But yeah, I got you. Go ahead.
I've read through these like 20 times, and I can see where certain things will not apply in our cases. But I can't. I mean, I can't remember these for the life of me if I was, unless I had it right in front of me. So that's just how I function. What we're trying to do by removing some of these, because a lot of these go into things that are not necessary for our cases, in regards to custody of our children, they can just be removed because a lot of us have not been arrested.
Yeah, I haven't. Yeah, exactly.
Okay.
505 through the end of the proofs goes into specifically goes into subject matter jurisdiction and jurisdiction period. And so you're going to want to leave those in.
Okay, you said what numbers?
505
505
through to the end of the proofs.
Okay.
Because I'm going to start by just reading the first couple of those proofs in regards to us, because what we're saying is statutory jurisdiction is a lawful jurisdiction lawfully created by the fundamental law of the land or common law, and that the undersigned is subject thereto and is bound thereto in any form or matter, contractually or otherwise. Now you have to understand these are all negative averment, so they're going to sound weird, but what we're demanding is that they answer in the positive. Okay.
Okay.
So what we're doing is we're prove that this is true. Well, that's what we're asking.
Okay.
We're putting in a statement that they have to prove is true.
Okay.
Like 506, proof of claim, the Uniform Commercial Code is codified within the United States Code, state of, and local equivalents, instrumentalities, and Code of Federal Regulations, state of, and local equivalents, instrumentalities, is not the controlling governing law of and within the alleged court of record within the above referenced alleged matters. We already know that they're trying to use the Uniform Commercial Code without our knowledge, and so we're forcing them to answer to this. And you're going to find similar all the way through to the end of this, which is 570.
So it's 500 through 570?
505 to 570 stays in. 1 to 114 stays in. The rest you can remove. It makes it easier on you to litigate if you ever have to litigate this.
You mean stand up for it?
Yes, exactly. Actually speak in front of a court officer.
Well, that's just for anybody that doesn't understand. So
yeah, no, I understand what you're saying. And something I missed up here. I'm going to go back because in the opening statements of the writs.
Opening statements, okay. Right, so top.
I'm starting to feel violated. I'm feeling violated.
Further.
Right here, wherever it's saying we,
Okay, hold on.
You're going to change it to I.
Okay. I
So yeah, wherever it says we, since you're going in a singular, you want to make sure that you gear this document to the singular. So I, being a plenary capacity character, blah 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 blah. I assert, declare, and aver that I am real parties in interest.
Would that be changed to the real party? Not parties.
Yes, absolutely. Anywhere where it's the
Multiply.
I want to make it singular for you.
Okay.
Leave the defendants because there are many defendants. Okay.
This ought to be fine, bud.
Okay.
Sorry, I totally forgot that part. But it's important to make sure that you gear this to you in the singular. Now you can do this in groups of people. Don't get me wrong. You can do this if you've got a group of 10 who wants to do this together with the similar cases, do it. Leave it as we. But you still have to take out the key tam because that's not you're not key tam.
Yeah. We will be made whole eventually.
Yep. Down here in the caveat, you're going to keep that the same, other than changing for your state.
Caveat.
And right here again, right before the caveat, right at the end of the proofs, you need to double check all the excerpts and make sure that they are for the singular for you if you're going in as yourself. Like right here, as our duly perfected and absolute secured interest, you say as my duly perfected and absolute secure interest. Now, I think what I'm going to do is go ahead and since nobody has done it, I'm probably going to go ahead and re-edit these for everybody so that we have a viable template. I'm also going to look at incorporating a lot of the judge advocate language into these so that we can better, so that we can get these also to the judge advocate with a better argument, because a judge advocate needs to know about this stuff happening. Okay. Hold on a second, folks. Yeah. Just make sure that you change so that you are. Can you guys still hear me?
Yes.
Okay.
Thank you so much. Where are we going at?
Make sure that you. Okay. Hold on a second.
We'll go from there. Okay. Okay. All right, Steve. Thank you.
Apologize for the pause here.
Bye. Okay, go ahead.
Okay, thank you, sweetie.
Sorry.
That's all right. Of course, make sure that you always check to where it's a state of. Make sure you get that in there in the correct state. Authorities do not change those at all.
Nicole, you had a question? Oh, I got you, Nicole.
Okay. Okay.
We are, for everyone, we are recording, so please mute yourself so we can hear everybody.
Leave the notice and cognizance required in the application to your fictional realm only. I love that statement.
Sorry. Get my jiggy on over here.
I'm sorry, I'm just going to blow through this stuff. You guys can read all this. These are all just your authorities for doing what you're doing with the writs. And I can guarantee that you're gonna make some people need to go home and change their britches with this stuff.
Joseph.
Remedies demanded, required, necessary, being duly perfected, due, and owing. You're going to need to read through all this. Change it to fix your, excuse me, fix your, for yourself right here. You're going to need to take out the names that are there and put in your own social security numbers, case numbers, and any that are unknown. Leave the AKA unknown, because they've taken everything that you've put into court and they've securitized it. They've sold it on the stock market, every bit of paper. And this is an attempt under the Sestakivi trusts, estates, and other trusts to recompense that, to get it back to yourself.
Can I interject right here?
Huh?
Do you think that this will show the fact of this? What I'm saying is I had a discussion today, and I haven't looked at them, but I did a 4506T and got my transcripts from the IRS. Do you think that will be something that will show on it? I have the forms, but I haven't went and picked them up yet. They're at the post office.
I don't know. You'd have to take a look at it. And if you did, in that section up above where you actually filed that and you received a response, that's where that would go.
Okay.
Because then you have proof of said issues.
Well, I got transcripts, 4 pages, 4 different envelopes, actually from the post office to my mother's, but I hadn't went and got them. They just came yesterday.
Okay. Well, you could add that into the discovery documents.
I'll let you know just quick. So yeah.
Make sure when you're going through all of this to double check to see if this actually applies to you. I know in the cases that I've worked with, that I've done for, say, the man who filed these down in Arizona, a lot of this remedy and relief we pulled out and just put in something different. We didn't put in everything that was here because they've demanded something different. I believe I've sent those out to a few of you. What I may do is actually go ahead and like I said before, I'll go ahead and make a template that you guys can utilize. Monetary damages. If you've been keeping track of all the monetary stuff that's happened within your case, you can apply all of that here. But if you haven't kept any track of it, you need to pull all of this out. Now, if your child is in custody, the government, our Congress, has okayed $1 million per year per person. That includes both the parent and the child. So you could put that in for monetary damages lawfully. Now, it'd be better to put that in and say, hey, I want half of it put into trust for my child. That way it doesn't look like you're just taking a money grab.
So does it work if the child was already taken and brought back? And does it work if the child was given to, what about if the child wasn't in custody of CPS, but went to the other parent who?
Okay. So if it's the other parent, that's private already, unfortunately, and this does not apply. because
okay, now what if while they had the child with the other parent, they violated all your rights as far as like putting the child in with CPS services, putting the child, loading the child with vaccines when you never vaccinated, things like that. Can that count?
I mean, technically, maybe you could go after that, but it would be questionable as if that was the other parent who had custody's decision. You probably couldn't get anything, but if they involved CPS or there was a custody holding by CPS, then yes, you could.
It was. Okay. And yeah, but it was complete, the switching was a violation from the beginning anyway. The switching was wrong. The switching custody.
Yeah, if it was instituted by CPS, yes, that would be state involvement. Whenever there's state involvement, then there's a problem.
It wasn't like instituted by CPS, but CPS was used on the scene, and then they used CPS services while he had him, and it was. And I've literally layered it and proven all the retaliation. Like now I've got it to that point.
Well, then that's evidence that could be put into this document, and one could get recompense for that. Yes.
Because I also had all the waivers for vaccinations and everything, and then lost the pediatrician that I had since birth because of this.
Okay.
Which was a holistic project.
You have to use your own discretion as to what you put in here.
Okay.
The more that you put in monetarily, the less likely you are going to be to get relief. I just have to put that out there.
Right, that makes sense. Okay. I already have the relief though. It is, but all right, thank you.
Right.
What if CPS has costed us a job opportunity?
How would CPS be costing you a job opportunity?
Because I work in healthcare and they put me on the registry.
Oh.
Yeah. And now my ex is using all the stuff CPS said, trying to fight in family court to win. Yes,
you could utilize that as well.
Okay. Especially because I'm the sole breadwinner. My husband's on disability.
Okay. Well, I mean, they're under state services. That it would be state custody.
Wonderful.
Mm-hmm. Everything down here after the monetary. Well, let's see here. If you have monetary, you want to leave all this in here anyways. It's about all the documents and papers that were written and writings that went into your case anyways. You're bringing them all over to your case with this. You want to leave everything in here that has anything to do with the United States or your state, because they're an unlawful fiction. They're acting under corporation when that's not how they should be interacting with men and women with hands and legs. And there is a lien on all of us that I'm not bringing up the judge advocate writ today because it incorporates that lien on all of us. But I will do a class here in the future in regards to that as I incorporate it into these writs. Because it's a lot more powerful. Because we can actually show that the Federal Reserve has done an unlawful act. Maybe I'll show that right after this, just to have fun. Everybody needs
Nick.
Yeah.
Oh, I just wanted to say John's in the house.
Hey, there he is. Okay.
Are there any questions? I don't want to disturb your presentation here.
Oh no, we're at the end now. Right now, I just went over the bill and petition.
Arbitration.
I just want to warn you.
This is just the writs that we're going over.
Oh, okay, okay.
I may make this live, guys. Just so you're aware, I may make this public live. So just since you're in here, John, just know that.
Okay.
All right.
So once you get this bill of petition and grievance edited for you, utilizing the proof of claims 1 through 114, and then removing everything up to 505 through the end of the proofs, you can actually copy and paste from this to the other writs, because they all have the same language. Now, does anybody have any questions on that?
These writs get filed into an open case or into a different court?
Okay, so these writs, and I haven't gone over all of them because there's actually there are 3 of them. Well, actually, there's 3 different. There's a bill of petition and grievance. There's a writ of error quorum nobis for your state court and the Supreme Court, and then there's also one for your legislature, which goes in the one for your legislature goes before this bill of petition and grievance. So you're going to have 2 with your legislature. I mean, did you see that down here? So let me bring up the. Let's see, which one is this? This is the one that goes to your courts, both your open case court and your Supreme Court. Can you see that all right?
The bill of petition and grievance?
You can only see the bill of petition and grievance. Okay.
My question, curiosity. Okay, let's say we file that in our current open case. What if they get so scared and they just say, okay, we're not fucking with this. We already know she might take it to the next level. Here, just have your kids. Do you still have to go to the extent to file them?
Well, if you file them into your case and they yield to you, why would you have to go any further?
Were they still without filing?
Well, I mean, I just didn't know if you had to sit there and stick with the process all the way.
Now, if they're willing to arbitrate with you or settle, I wouldn't bother going further.
Take your kid and go home.
It's gonna run.
Just asking, just in case, any other parent had that thought.
I mean, only if you're actually wanting the remedy on paper. I mean, you gotta understand there's remedy judicially and there's remedy administratively.
Yeah, but I wanted to, so I would need to go all the way to the top if I also want to sit there and help others as well, correct?
Rephrase that question, please. I don't like it.
Like you, okay, like filing it for, it to be on record and to be on file. I mean, will that help other parents as well, even though it's filed with just solely mine?
I mean, you're not going to get a case law off of it, no.
Oh, okay. Okay. I was just asking. I'm sorry.
But if enough of them do it, you may alter the system in that area.
Oh, that's nice. Okay.
Well,
but yeah, it's a civil thing, and so there's no case law. I mean, I've never really even seen so-called family case law per se in that sense.
Okay.
Well, but on one hand, Christina, if you file it and you get your child back and they just say, leave us alone, go away, that doesn't stop you from the next parent that calls you and says, my children has been kidnapped and I need help, that you teach them this writ and help them through the process of doing it for themselves.
To go, but yeah, that's what I'm talking about. Okay. Thank you, Dawn. And sorry for my question, John.
No, if I don't like the way it's phrased, I want it phrased another way. That's all.
Now he's starting to talk like a law sayer.
Yeah, I mean, you got to be careful there. No, I mean, anything that goes in there, it may make them think twice. If multiple go in the same jurisdiction, maybe it alters the way they do things. Maybe they act a little more proper.
Okay. See, it's just like what would be nice is you're going to file it in your county, which is Jackson. Right. The county in which kidnapped my children were Franklin. The county in which Krista and Tisa were in Sedgwick County and in another state. And she's, I think, in Jackson or I believe somewhere up there. So if even though the lower courts each get it, but each one of us is going to file to the Supreme Court. That means the higher court's going to get multiple from different jurisdictions.
Gotcha. Okay. Okay.
And if you understand their system, I sent out the thing the other day to.
Hey, Tom, before we bang our heads against the rock, Tony, do you think we can do it?
No, say that again. I barely heard somebody.
Sorry, forgive me. That's I have people in the background. He's in a dungeon.
It's a non-believer.
He's in a dungeon. Here, I'm gonna get my headset on so there's not any crosstalk.
There's a system in place since probably 39. I think it's 39 federally. The states were probably not long after, where they have a judicial conference and they have an administrative section of the courts, and they're the ones that determine policy and changes in rules, procedures, and processes. And that's where I'm saying, you know, if people are filing in the same jurisdiction or state, that you may start to see them change and alter what they're doing.
So if people want to see what John's talking about, I put that right down in the chat there. You can see that there's actually 3 entities, I believe it is, John, that are acting under this.
Federally, I think it's the administrative office, and I think a judicial conference or something like that. It's named something like that. Then the judicial conference is basically, they're the ones that get together and decide the rules, processes, and procedures used.
Right.
And the administrative office is actually violating a lot of law because they are interfacing with the legislative, the executive, and conspiring to affect due process. And you're going to find a similar structure in the states. As to when it happened in each state, that's a different story for each state. They all have it.
Okay, is it in profile, the Administrative Office of the U.S. Courts Annual Report? Because I just put the link in, and then a bunch of them just popped up.
Mine went straight to it. Looks like
in answer to Ramona, yes, you probably have to dive a little further into the actual laws themselves to find when the state or the Canada went into being a de facto government.
Okay. I'm going to tell you, I think everybody went in around 1933, give or take a few years worldwide.
Yeah.
And once again, I'm going to say that 2015, it was reorganized worldwide.
Why 2015, the magic?
All I know is a bunch of stuff happened here on paper, and the Pope went to the UN with the World Constitution in September. So.
Okay, thank you.
You know, on top of that, I just heard too in '82 that way they conspired with the Vatican and the Queen, and the United States also was in '82. As something might be looked at in that way.
Hey, well, I know for sure '84 because their business records go pre-'84, and then after that they give an exact year. Probably some sort of reorganization and bankruptcy.
That's when they constructed the alliance. Was in '82. Was what the presentation I got today.
Highly plausible.
Now, John, I know you're emphasizing that we should look to that Advocate General writ and incorporate it into the writ the state writs that we're utilizing. Can you explain to everyone here how we should do that?
Yeah, just whichever writ, state or federal, just remove the initial arguments up to the paperwork that's listed there and just replace it with the same portion of argument from the JAG.
Okay.
And because it's international law, a treaty, it is part of the supreme law of the land pursuant to Article 6, Section 2, and therefore it's applicable in a state as well as federal.
Okay.
And that may cause some pressure because these international treaties that if they're breaking them, it's actually constituting war crimes against the people.
Yeah.
The federal also, I mean, I added the specific performance and accounting to it. So you can always add that under the writs as well. I think I changed it to in-law and equity as well. So you may want to look at the I think I did that at the very top of the judge advocate. So really, if you copy and paste from the top down to on the judge advocate, it looks like page almost the end of page 4, and just insert that after removing the beginning same section state and federal writs. I think it's I expanded it out slightly for
Okay, I was looking at that today and I can see what you're talking about.
You know, I added free will choice 0 point. They're not gonna like that. Customs, they're not gonna like that. But we have the right to invoke both.
Okay.
There's no reason not to. Free will choice is really a universal law that, I mean, they can con you and get you to go along, but they still need to get you to go along in some manner.
I agree with that. I don't know. My opinion's always different because it sounds like we have no choice but to keep these guys no matter what. We have to keep our rulers. It doesn't seem right. We have to keep them no matter what.
As a maxim of, and really the maxim would be universal law. You must have clean hands to get remedy.
Yeah, but what I'm saying is if somebody thought of that. Somebody can just say, no, I don't agree with that for my personal self.
Well, I mean,
we're in a situation now that where even if we're on a space rock flying through space, she can't be the queen. You can't be the pope. People are going like, come on, get out of here with that. I mean, people are starting to wake up to that fact fast. I'm telling you, the streets are starting to be like, yeah, you're the queen of the space rock. You know, so we're going to figure out something to where we don't have rulers. Don't you guys agree with that? I always push that at the end so like we govern ourselves, you know?
I mean, if you look at the scripture that's in those, that's the underpinning of their system. And you'll see clearly that you are permitted to be a king without subjects. You are permitted to just live your life. You're absolutely permitted. And their system, the foundation of their system is those maxims and those specific scripture pieces. And the only thing the Pope is using is the fact that you haven't woken up and said, no, I'm awake. I can manage and handle my own affairs. And you show that you can manage and handle your own affairs.
But this saying, who is here? There are pedophiles over there. We're proving ourselves to the pedophiles. It still doesn't make sense.
Well, I
mean,
you're only, I'm not saying you prove it. You don't have numbers. So you have to prove it. Now you get 3.5 billion people to tell them to go jump off a bridge. Well, then you ain't got to prove it to them, but you ain't got that.
Well, we're getting it. That's why I'm talking to everybody. And some people say yes, some people say no. I'm just saying that they have 3D printed mansions, 3D printed cars. You guys can Google this today. The technology they already have 3D printed mansions, cars, and AR-15s. If we got rid of these dudes, we go right into paradise. You know, so you have to admit that. You guys seen this stuff? The technology now has let us pass these guys. That's all I'm saying. Like I said, the lawyer job is an app. The judge job is going to be an app. It's just going to be that. So we don't have to deal with the personal BS. That's what we're going to do. So.
Well, realize
I like to have the discussion with the people. I like to have the students. I like that discussion. I don't mean some weird or nothing. I like to have the discussion with people just to, people just to get people talking about it.
No, I agree. The discussions need to be had. I just you need to realize at this point, any plan that moves into place is theirs until you see massive numbers of people saying no. So don't ever let Q or Trump tell you trust the plan. Don't believe it, because that's their plan. Okay, I'm telling you straight up, it's their plan.
No. I know. That's why I try to break the taboo of talking about it in public. That's why I just come out and say it. I don't mean to be rude to anybody. I promise you. I just try to break the taboo to even talk about this stuff, and we can never get rid of them if we can't even speak about it, openly.
No, it's being spoken of, but it's in small places, and it's, even though it's out there, it's still kind of secretive. People are going to do what they're going to do as long as they're comfortable.
Yeah, that's what I'm saying. I'm not even talking war. These guys work for us. I not mean war. Just stop paying them is all I'm saying. That's as far as I'm going. We stop paying, pull the purse strings until they start behaving right. We're not talking war with our employees. No.
Well, I mean, that's exactly it. They need to be addressed as an employee that has become belligerent. Absolutely. And I mean, if you look at what Phil and Gene do, they refuse court orders. No, that's not right. And here's why it's not right. So no, I don't accept your order. Take it back.
As I said, my case they did out in the open. Everybody knows what happened. It's out in the open, and still nobody cares. So it's just like, man, I can't believe it. It's so shocking. It's like, you guys gotta go at this point. Don't vote or something. Everybody don't vote. Something. We can't just continue the same thing, and just continue putting these guys in. As soon as they get in, they turn into our overlords.
I understand that, but we don't have the numbers for that to even happen. So we sit there and have to at least, go with the flow with what we're doing now for us. We can't help it that other people are asleep. The only thing we can do is educate.
Yeah, no, I'm trying everything. I'm putting in the paperwork. I'm hiring a guy that's going to help me go through all this because I don't understand any of it that's in another language. So I'm hiring somebody that's helping me go through all of this stuff. So I understand. I want to do everything. I'm just saying we should always keep it on the mind that we want to eventually get rid of these guys. We don't need them any longer. Not as much government. Small things, yes, but how we have it now, no.
I think actually with technology today, the need for a government has outlived its usefulness.
I agree. 1 million.
That's still true. Yes. I wanted to say that, but they said I'm crazy, so I didn't want to go that far. But yes, I did want to say that.
We should be self-governing a long time ago. This is archaic. What's happening, and it's honestly, it's why. But this hopefully this will be live. I would like to make this particular one live for the public to see. So I just want to add something. People that are watching this or will watch this need to come alongside us and grow this with us. There is the manpower out there, but too many people are still asleep. And I know, because I know by the messages I get around the damn clock, how many people really don't care about their children as far as I'm concerned. Because if they did, they would be doing what we're doing. And there shouldn't be 10 advocates in the front lines every day fighting for your kids when you're not fighting for your kids. And I don't care if that offends anybody, because after 2 years of Facebook and 11 years of advocating nationwide, and I see how lazy parents are, when answers are out there and solutions are out there, I'm going to tell you that you're being lazy and you're not doing what you could be doing to fix this problem, because we do have enough numbers and we could have put this to death a long time ago. And it's very frustrating to me to know that in the middle of the night, while I'm sleeping, in the rare occasions I can sleep, somebody's house is being circled by 20 police officers, breaking down a door taking kids out in the middle of the night in the name of protecting them. So I don't know how people can just sit back and do nothing. I really don't get it. And that's all I'm going to say.
That's true. That's 100% true.
It's human nature.
That's true.
And that's what they use against you. Human nature.
It is human nature.
Here you go, guys.
That's what it is.
What happens if you take both at the same time?
You could say,
that's what I'm saying.
Purple.
or you could say inhuman nature.
Purple.
Purple. You might see purple. Purple Murple.
You know, I don't want to seem crazy, but man, I don't want to leave this for my son, and now he's growing up into slavery. It's crazy.
That's
well,
right.
You know?
That is right, but you have to remember it takes 1.5 generations to make history.
Mm-hmm.
Straight up.
Mm-hmm. Yeah. I'm just ready to. It's falling apart on its own, so I don't have to do much. You know, it's already falling apart.
Well, just realize if it's falling apart, it's a plan.
Right. And now you're seeing more people literally, I'm not telling you that I'm encouraging you to do this, but people have had enough. And when they're showing up to take their kids now, they're shooting them dead. Okay. That's what they're doing. So that's going to wage even more. It's going to wage even more of a war. And if you walk into a family court, you're going to walk into at least 20 RoboCops checking you to see if you have guns, but just so that they can protect the phony administrators that are inside that are about to destroy your family and your life. But who's in there to protect the families that are going in the first place, like sheep to the slaughter? And now, you know, the one great thing that's happening is that thanks to social media, we've been exposing this all over the planet, and you know, and some good things are happening and breakthroughs are happening. But we can really grow this if people would really, really start to do something. If each person, I'm not saying everybody has to do like what we're doing around the clock stuff, but if each person put in literally a small percentage of their time to try to do something. Or when they tell me, when I get my kids back, I won't stop. And then you see them just go into la la land, and they did stop. So they gave their word and they never supported their word. All right. So if each person actually put in literally a fraction of their time to start doing something or to show up or to just do something, you would see this collapse at a faster rate. And it's really sad to me because how many billion people do we have in United States alone? Does anybody know the exact number or the round number?
About 340.
300 million? Yeah, 3 something.
Yeah. I mean, come on. And you're not, and there's nobody that's not affected. There's not a soul that's not affected by it. There's not a soul. I don't care who you are. You are affected. And the bigger you are, the worse it is for you. The worse for you. So if you're in a place of some kind of a position of power, it's worse for you because they want you. Okay. So you'll see, and you'll regret that you didn't do anything about it.
The problem is so many people are sleeping and that, nothing's going on because it's not happening to me. And we need to fix that mentality.
Yep.
But even the people that it is happening to, even the ones that it is actually happening to, okay, even those people that it is happening to are not doing anything about it. And I kind of liken it to this. If your kids were in a burning building, you wouldn't be like, I got to heal myself first and take care of me. And no, you wouldn't. You would do what you had to do. Well, your kids are in a burning building right now. Okay. So it's like, how do you sit back and do nothing?
So. You know, I think a lot of it is depression. A lot of people are going through, for me personally, I just say, because I go through weeks of just, I don't even feel like getting out of bed sometimes. Like, man, I've been fighting for going on 6 years. So crazy, you know? And I think for me, what slows me down is depression.
I can absolutely support that and everything. And that's why, like, this is like a fellowship here too. So So even if you're a little bit of nothing, even if you're a little bit of something that you're doing is just getting in the classes and sitting with people, you've just done something. So you've actually taken an active stand to do something. You know what I mean? And then getting that support helps to build you up, and iron sharpens iron. But, you know, we can't even God yelled at Elijah and told him, what are you doing in the cave? Okay. So that's not a cruel thing. It's actually something to say to you. I put my power in you. It's time to use it. It's time to use it right now. You know, and what did he do? He slayed how many false prophets, and he went and hid in a cave. Right. And God yelled at him. He rebuked him for that. So we're at a time right now. It's pivotal. You know, I'm not saying people can see the future, but we can kind of see the future. And it's not a good one. It is not a good one. No, it's not a good one. It is not a good one. You know, and it's like how many times this alarm has to be rung, okay, before people are like, wait a minute, there is a fire. And what the hell am I doing here? I'm sitting here like eating a sandwich. So
sitting on the sidelines.
Sitting on the sidelines.
I know that's. Hey, you know, I wanted to say too. A lot of this, like the stuff that's coming to transhumanist stuff. I don't know if you guys have seen this stuff yet. Like I said, I just want to talk about it's weird stuff, but it's coming. It's what it is. A lot of this stuff is in the Bible. You know, a lot of stuff is in the Bible. And talk about the deaf hearing, they do that now. And the blind seeing again. Like I've noticed, it brought me back to the Bible. Hey, what's going on? Excuse me.
All right.
Hey, what's going on in there? Hold on,
I'm going to take off the live portion of this. You guys can, if you want to do like Q&A or whatever. I need to get back into Zoom here. And if anybody does want to get into these classes, especially while writs are being taught, because I think I'm going to just live this off of live tomorrow sometime. You can get in. The website is always on my page.
Does anybody have any questions on editing the writs? I know I'm going to work on getting an editable version for everyone and instructions on how to do it here soon. It's going to take me a little bit of time. If anybody has any other questions on doing it themselves that they want to, feel free to ask.
Nicholas, Sean filed it, and Ghost gave us some pretty good pointers as to how to, what kind of judgments to put in there and how to put that together. And he had asked me to put it together based on what he recommended and to send it to you for you to send to Ghost for him to review it. And then maybe use something like that as a template or whatever. So it's going to be interesting because right now it's still in family court. This Friday marks the 11th day. We're probably going to put summary judgment to it next week. And it'll be really interesting. I'm looking forward to seeing what the results of this is going to be. But we'll see.
Well, the simplest version, let me bring this up here really quick because I've done some edits for other people. One actually went in, I'm going to bring up the one that actually went into Arizona legislature today in regards to the writs. Let me find it here. I'm going to bring up the bill because it has the remedy at the bottom. It's really simple. And may be helpful to others as to how simple it really is. Let me go down to the bottom and to the now, do know that this person is a private person. I ask that you not disclose who I'm showing it about.
Okay.
We're still live though. Is that like, I can't, for some reason, I can't turn the live off before you show it. I mean, because it's private live right now, but I'm going to make it public live.
Go ahead and pull down the live so that I can show this to everyone here.
So I can't do it until you stop screen sharing, I think.
I just did. I just did.
Let me try to figure it out. Hang on a minute. I'm going to try to figure it out then.
We're looking at the simplest version to make you whole and to make your children come home.
Okay.
Shoot, I can't. I don't know why it's not letting me.
You mean the writ itself?
Well, in the remedy part.
Okay.
The remedy is it can be made very simple. Okay, hold on. Let me see if I can't just for the moment pull out the names that are here. God, do I even have the right one? Yeah.
I should have options to turn up. Christine, do you have option to turn off the live? It's not letting me.
How do I go about turning it off? I'm unsure.
So my screen is not showing what it normally would for some really weird reason. So basically, when I would normally look at my screen, there'd be a more button, and when you click it, it kind of goes up, and then it should say stop.
I hit the more button and it says invite.
Okay. Is there anything else to your right that's like dots or anything, or options or anything? This is crazy. I can't.
I have the three dots down at the bottom.
Okay, click those. See what comes up.
Yeah, it just says invite alt plus L or 1.
Probably because you're just.
Oh, well, I've got all I'm showing is record and disconnect audio.
Oh. Okay, record just means like you're trying to record for yourself.
Right.
But I need to stop live. I'm trying to stop live and I don't have a full screen. It's just bizarre.
I'm not showing anything about that.
And I can't even get out of here if I wanted to. Like if I want to leave and come back, where then maybe I can do it.
Well, it actually has you as host, Francesca. So
I know it has me as host, but I can't do any of the host. I can't do any of the like host capabilities because of the way. I don't know what happened.
Yeah, I can't share this considering it has proprietary information in it.
I know.
It's too late. I already found it and I sold it. Haha.
Well, I'll figure it out. Hopefully.
Well, isn't it? I mean, because with the remedy and the relief and the original writ is quite extensive for things they were going after, which would be eliminated anyway. Correctly.
Well, let me just put it in there. As far as like if you're trying to get children out, all you would have to add in there is demanded and required is in any order, judgment, decree, and or writ necessary to release and return from any and all care, custody, and control the biological property of the undersigned, aka the name of your child. It's that simple. And you just add it in.
And there's another clause there. You may want to include the one that's stating that you want any and all other remedy and relief for the intent that goes towards the intent of the document. It's a very general clause there.
Yeah.
I mean, you can pull out the tumultic and the other various things that we're screwing them with them on. But you would want something like that to the full intent, relief for the full intent of the document.
Here we go. I'm gonna show it with I just removed the name so that everybody can see it since we're recording. So here's the remedies demanded, required, necessary, being duly perfected, due and owing. Demand and require in any order, judgment, decree, writ, and or tangible medium necessary to void and extinguish any and all court processes, procedures, orders, judgments, etc., without limitation and with reference to the undersigned. And that's probably already in the original writs. Demanded and required is any order, judgment, decree, or writ necessary to declare that the defendant possesses absolutely no documents, papers, digital data, tangible mediums, and or tangible items, nor did any ever exist, which demonstrate and prove that the undersigned real men living soul was a willing, knowing, intelligent, and intentional party and or signatory to any social, public, private, commercial, ecclesiastical, military, universal, and or compact. I don't want to go through any more of that because I think
by the way, that's the declaratory from the.
That is the declaratory. Yeah. Demanded and required is any order, judgment, decree, and a writ necessary to expunge and destroy each and every record, regardless of form and format of the undersigned, in any way maintained and stored in care, custody, and control of the defendants.
Hey, Nicholas.
Yes.
Based on that you just now read, our grandchildren are mentioned in another case as having oral sex with a whole bunch of kids, and it's in another case. Can we put that case number in there and say demanded and required? Is all those records expunged from that particular
Absolutely.
Case?
Yes.
Okay.
Yes.
Thank you.
You would have to put that case number in because it involves the,
your kids.
Your kids or your really your property.
Right.
I mean,